and visible to you all?
Yes, sir.
Great. I'll just share my screen. Is the screen visible?
Yes, sir.
Yeah. So let us begin with the session. This is basically a session pertaining to the arbitration test. Now, before I start, the arbitration, this has boomed, we can say, in the last decade. Now, the reason for this is maybe awareness of people, the way business is growing. Secondly, the way technology is advancing. Hence, we definitely need a recourse to resolve our dispute by the way of a mechanism which will help us. So, basically, arbitration is very important when it comes to resolving the dispute. Now, when we talk about arbitration, it's ADR, basically alternate dispute resolution. Before we jump onto the topic, let us first understand the judicial mechanism, the legal recourse mechanism in India. In India, we all know there is a huge pendency in various forums. Let us take an example of a civil court. Let us take an example of a consumer forum for that matter, which was actually a specialized court. Let us take an example of RERA for that matter. Let us take an example of NGT. Let us take an example of NCLT. Every forum has a lot of pendency. Earlier, there was a traditional mechanism, only courts were available. Okay, but over a period of time, if you see, specialized courts are established. Consumer Act came in 1986, consumer forums were established. In 2019, we got a new law with the same forum. RERA, for that matter, we can say is a very latest law, 2016, like almost a decade right now. So RERA authority have given a specific two-tier system, RERA authority and appellate authority. Coming back to NGT also, similar mechanism. Environmental law issues, before that authority only. NCLT, a very important change. The matters with respect to Companies Act, matters with respect to Insolvency Bankruptcy Code before the. So now this all efforts are done by the government authorities. What is the reason for the pendency? The major reason is the ratio of population versus judges is very less. Maybe it can depend on subject matter. Maybe it will depend upon various, issues with respect to infrastructure. That is again one of the biggest problem. Luckily, we are moving to a system which is now moving towards online system. But again, going online or going virtual is not going to help us. Okay. Hence, ADR generally helps us to resolve our dispute in a more easy way, in a more amicable manner. Now, this particular topic is again very important for us because the way industry is changing, the way scenarios are changing. Now, for example, whenever any of the client approaches us, we have to draft an agreement. So, as an advocate, the very important thing for us is to protect our client's interest. This is again very important. So, for protecting the client's interest, it is important to understand the needs and requirements. So, with all the needs and requirements, dispute resolution clause plays a very important role. Now, in that, we do advise clients to have a dispute resolution clause, that is arbitration clause. Okay. In various government contracts, government tenders, you will find out various clauses with respect to conciliation, respect to mediation. Those are also very important. Now, let us first understand, what is this arbitration, conciliation, and mediation. These are the three important dispute mechanism forum which are away from the traditional system. So arbitration, I'll just quickly take 5 to 10 minutes to explain you all these three terms so that you get a clarity, and then we'll move on to the actual concept and topic. So arbitration, for that matter, where a third party, a neutral person is appointed, okay, to resolve the dispute. Now arbitrators are generally appointed maybe by mutually by both the parties, or if not, if parties are failing, then the high courts will appoint the arbitrator as per the Arbitration and Conciliation Act. Now who are arbitrators basically? Arbitrators are retired judges. Okay. Those are also advocates, practicing advocates who have a specialized experience in that field. Okay. Secondly, how does an arbitrator gets nominated? Okay. So first of all, the first option with the parties are both the parties can jointly appoint the arbitrator. The first thing. If they are not able to jointly appoint the arbitrator, then the parties can approach the high court, and who will nominate the arbitrator to resolve the dispute. Now, more or less, arbitral proceedings are just like court proceedings, more or less. Okay, when it comes to the steps which are followed. Where, for example, in a normal civil case, how does it runs? The plaintiff will file the plaint, the defendant will file the WS, that is written statement. Then, based on that, the matters will be proposed for issues. Issues will be framed by the court. Once the issues are framed, the matter will move on to the evidence stage. There will be evidences filed by both the parties, examination, cross examination. Once it is done, the matter will go for final arguments. After final arguments, the final order judgment. Similar pattern is followed in arbitration, but the best part of arbitration is civil procedure code is not purely applicable under arbitration. The Evidence Act, the new law which we have got, Bharatiya Sakshi Adhiniyam. Earlier we had the Indian Evidence Act, which was older law which we were following. But recently there are changes now. So we have a new evidence law, that is Bharatiya Sakshi Adhiniyam. I think 2023's Act that has given a lot of changes. So now evidence law and civil procedure codes are not purely applicable for arbitral proceedings. Hence, this is why arbitration is speedy. Arbitration helps to resolve the dispute in a very easy and amicable way. Now, the only part here is it is authoritative. Arbitrator's decision is binding on both the parties. Arbitrator will pass an award, which will be in either of the favor of the party, or it can be neutral award also. So this is about arbitration. The Arbitration Act regulates it completely. Coming back to conciliation. Generally, students, or in fact, many people gets confused when it comes to conciliation and mediation, because both the terms look similar, process is similar, but no. As an advocate, as a law student, we need to understand what is the difference. For that matter, if you see, in cases of commercial suits which are filed in the court of law, there is a compulsory requirement for the parties to go through mediation. Okay, now let us try to understand the difference between the two. First, conciliation. Conciliation is basically a process where a person is appointed, okay, who will try to resolve the dispute between both the parties. By maybe he might ask the parties to come to a conclusion, discuss among themselves, give them a way out, and then they can come to a conclusion. But here, the decisions, the opinions, the suggestions given by the conciliation officer are not binding. Let us understand this with the help of an example. Whenever a RERA case is filed, that is Real Estate Authorities Act, we have a separate law for that. If there is a real estate dispute among any of the builder, allottee, home buyer, maybe there is a delayed possession, a builder is not paying the amount, no interest is not paying, no compensation is given. In all such cases, we can approach the RERA authority. Now, the moment a allottee will file a case before RERA, RERA will first direct the parties to go through conciliation hearings. Means what? A person will be appointed by the RERA authority. His job is to call both the parties, conduct 2 to 3 meetings. Okay, and in those meetings, he will only give suggestions. He will first understand the dispute. What is the say of the builder? What is the say of the allottee? Why they are not able to come to a conclusion? What is the reason for dispute? So he will just give the suggestion. Maybe he will say both the parties talk among yourself, or talk, come to a conclusion if you are able to, and let's resolve this. So he will take efforts twice, thrice, that's all. Then he will pass his specific order, which will say there is no amicable solution arrived between the parties, and hence the matter should be referred to the tribunal. Then the tribunal will run the matter just like on the basis of merits. complainant will file the complaint, respondent will respond to it, then it will go like a normal matter. Similarly, in cases of MSME proceedings, that is micro, small, medium enterprises, we have a separate law for that. Basically, for micro, small, medium enterprises, those who are registered with the government authorities. Now, in that those cases also, if the parties want to go for recovery, so rather than going from the normal civil recourse or normal commercial courts, they have a right to file a case before the MSME forum. That is a facilitation council. That facilitation council helps the parties to recover their money back just because they have registered as MSME. So under MSME also the process is same. The moment you file a case, they will direct you to go through a conciliation process where a person will be nominated, he will try to resolve the dispute. Okay, this is now conciliation. When it comes to mediation, here in mediation, the appointment of that person does not depend on any authority. Now, for example, in case of RERA we discussed, RERA may the RERA authority will appoint that person. In case of conciliation, the MSME authority will appoint that person. But in mediation, it will be a normal third party neutral person who can be anybody, maybe a common friend, maybe a chartered accountant, maybe an auditor of a company who knows the subject matter of the case, and maybe he can guide to some extent that this is right, this is wrong, this is the best way out to resolve the dispute. This is a win-win situation. That is the mediation. So here we have to understand the difference between all the three terms, that is arbitration, mediation, conciliation. Now, particularly talking about this particular course, so now why arbitration matters, that is very important. So the very crucial and very important reason, for that is the growing pendency in the court. Now, have you ever imagined what is the life cycle of a normal civil suit? Now, whenever a client comes to us and he says that, let us file a civil suit. In that case, first of all, our duty is to make them understand how much time it is going to take. In many a times in movies, you might have seen तारीख पे तारीख तारीख पे तारीख. No advocate can give a surety कि आपका केस 1 साल में, 2 साल में, 3 साल में, 5 साल में, 10 साल में खत्म हो जाएगा. I remember, a dialogue from the movie Lagero Munna Bhai. In that, in one of the scenarios where they go to a court for getting the resolution, the advocate says 6-8 महीने में केस खत्म हो जाएगा. 6-8 महीने. Then he says, लिख के दो ये. So he says, no advocate can write. So, और इसमें पता नहीं चलता है कि how much time it will take. Then he says, you are saying 6 months, write down 6 years. I am ready to wait 6 years. He says, I cannot write it down. So just imagine, where he is assuring 6 months, but he is not giving a surety in writing. Ethically, advocates are not allowed to give any surety because every time the matters depend upon various in scenarios in the court of law. Okay, so first principle for advocate is not to commit in anything to the client in the reference to winning of the case. Okay, you fight it. Fighting is our right. We have to fight for the case, but not give any surety. कि 6 8 months में खत्म हो जाएगा, 2 साल में खत्म हो जाएगा. So the very first reason behind it is the pendency. The normal life cycle of a normal civil suit is minimum 10 to 15 years. We have seen suits which are pending for 20 years, 25 years. People are coming every time in the court of law just to, make sure that case is, completed in time. But this does not happen. Now, what is the reason for it? Reason is, as I told, every day there are more than 100 matters listed on the board of every judge. So just imagine, let us take an example of Bombay High Court's cause list. Take an example of district court for that matter. The matters run beyond 100. So is it practically possible for any judge to sit 6 to 8 hours in a day's time and close the matters? Not possible. Because again, the problem is about population versus the judges ratio. This is the first thing. So today, it is important to divert ourselves from the traditional mechanism to a ADR facility. Okay. Then business preferences. So very important. Arbitration, the matter remains confidential between the parties. So it is very important that now, for example, in cases of civil suit, there are online platforms wherever the data will be easily available. What is the stage of the case? Who are the parties? Everything. But in case of arbitration, the data is not available. So the dispute remains very confidential. Maybe at any point of time, the dispute can be resolved easily. So that is one of the important uh, reason for opting for ADR. Growing demand, again very important. Recently, I have heard about that earlier specialization for law, that is LLM. This course was given only for limited subject matters like constitutional law, IPR for that matter, business law, business and corporate law. But now there are institutions who are offering ADR as one of the specialized subject under LLM. So this is again a best thing for us to learn. And maybe those who are interested into that, they can think about it, that at the end of your 5 year law course or 3 year law course, okay, you all can opt for that also if your interest is diverted there. So this has become a very specialized field. Knowledge of this is again very important to ultimately guide the clients to resolve their dispute. That is again very important. Now, yes, coming to ADR. So we have discussed in our, introductory part, is a mechanism which is out of the court, which helps us to give a decision. Now, if you see, various courts have adopted this practice. Let parties first try to negotiate among themselves and try to resolve it. If they're not able to resolve, then the matter can be decided on merits. So various forums have started this. Many a times, in the concept of lok adalat. What is the concept of lok adalat? Every duration, lok adalats are formed, established in various courts where judges sit like a normal person and then he tries to resolve the dispute. Now, only few disputes can be resolved by the way of by the way of lok adalat. Maybe it is a property issue, maybe it is a land related issue. It is a maybe a some to some extent family matter, family dispute of partition, or money recovery suit. In all these subject matter, the issues can be easily resolved. So many a times, people do not, confirm on the cost. They do not analyze the cost. Okay, how much time I have to wait to get a court order. Today, if I take up 1 lakh rupees where my 20 lakh rupees are pending, in that case, they need to take the financial call. What is best for me? So in many cases, it is the financial call. Now, in scenarios where clients ask us that my 10 lakh rupees are to be recovered. So in case of 10 lakh rupees, if we give him the budget of his case, handling this case and paying the court fees, that will go to 3 to 4 lakh rupees in all, in the whole of the life cycle. So it is again a very important to understand the commercial call which we need to take. So in ADR mechanism, things are very much easy, and where processes are very much limited, so you get the decision quickly. Now, yes, so this particular course is very important to understand the basics of ADR, very, very important. The arbitration and conciliation. Secondly, how arbitration starts, what is the process of under arbitration, what are the timelines, that is more important. Secondly, what are the implications of the proceedings, and what rights courts to have to interfere. Okay, so this course particularly will help us to understand the subject practically. Now, as a law student, our first duty is to read bare acts. Very important. But sometimes bare reading of bare acts won't help you to understand. You will read 10 times, 20 times, unless and until you are, getting any example or, reading something about it in more detail. Then only you will be able to understand it in practical sense. So reading bare act is the very basic thing. With that, its understanding will help us. So basically, this course has been designed for the law students, the fresh graduates, okay, the young advocates, junior associates. So these days, if you see, the advocate practice or law firm practice is also diverted towards arbitration. Various law firms, for that matter, do have a separate arbitration team now. Those who are purely into arbitration, dealing with arbitration cases, handling the matters for their client, representing them. Now, maybe that is an institutional arbitration, or maybe it is through an ad hoc procedure. Okay, so what is institutional arbitration? What is ad hoc arbitration? Everything will be dealt in detail in this particular course. Now, the basic objective is understanding the ADR legal framework, basically the Arbitration and Conciliation Act of 1996, learn practical arbitration processes, then develop drafting and advocacy skills, understand arbiter strategy and tribunal functioning, gain exposure to real world dispute resolution. So, all of these will be included in this particular course for you all to understand the subject in a more detailed and practical sense. Now, what are the key findings, key learnings which we'll get from this particular course? First is drafting. Now, why drafting is important? Drafting is very important because that becomes a base for any advocate to lead his case. Now, I'm talking from a practical example. It starts with drafting of an arbitration clause. Now, I'll give you an example. The very important thing what court will observe is whether parties actually intend to resolve the dispute by the way of arbitration. Okay. So now if parties do not intend, then there are chances that they might not put the arbitration clause in the agreement. Because when the arbitration clause is there in the agreement, then that clause becomes binding and parties cannot approach the civil courts. This is very important. So drafting of arbitration clause, drafting of arbitration agreements, drafting of notices. Now, why notices? Because when you have to invoke arbitration, you need to issue a notice first. Okay, notice under section 21 of the act. Then parties will act upon it. If the opposite party is not ready to or willing to appoint the arbitrator, then you need to approach High Court under section 11. Section 11 is a basic application for appointment of arbitrators. So now what are the powers of the court when it comes to section 11 applications? Court will consider only few aspects. Court will not deal into the merits of the case. Court will first see whether there is an arbitration clause, whether section 21 notice was issued, whether this is within limitation, whether the clause is correct, appropriate, and not vague, and whether the opposite party objects the clause. All of these basic things will be dealt, and then they will pass the orders. Okay, so limitation of courts when it comes to interfering under section 11. That is again very important and crucial. Secondly, filing of your statement of claims, statement of defense when the arbitration starts. Then procedural application, maybe you want to file an application for production of documents. What I have practically observed is, to certain extent, few of the advocates do have to refer few of the application as per CPC. And that is absolutely correct, because it's not that when we say there is a section under arbitration act which says CPC is not binding, evidence law is not binding, that is all okay, but you cannot move away from the normal procedure. So binding nahi hai, this does not mean that you cannot look to the provisions. Basically there should be some law, because arbitration conciliation act will not give you a complete procedure. It does define a specific procedure for it, but not in detail. Hence, to some extent, you will have to take help of CPC also. What are the powers? So that is very important. Next is the proceedings. How to file it? What are the stages under it? The responses, the appointment of arbitrator, the conduct of the parties, interim reliefs. That is again very important. So there is section 9 application, which is generally filed before the district courts, because see, many a times when dispute arises, there are apprehension to the property, apprehension to maybe goods which you have given. So in that case, your arbitrator's appointment will take a lot of time. Okay, you will issue notice, they will receive the notice. Within 30 days, they have to respond to the notice. If they are responding in negative, then you need to approach High Court. So in fact, appointment of arbitrator might take minimum 7 to 8 months, but you cannot wait up to 7 to 8 months. So in that case, there is a remedy given to you all, that first of all, you can approach the civil courts for getting interim reliefs. So that is again very important. What are the powers of the court under section 9? There is a parallel section to it, that is section 17, which are interim powers granted to the arbitrator. So we need to understand how the mechanism flows. So this particular topic under that module will help us to understand the interim reliefs. Importantly, the award which will be passed, the award should be reasoned award. Award is always subject to challenge under section 34 of the act. And secondly, when award is passed, what are the criteria and grounds for challenging the award under section 34? So, in the recent times, there are multiple judgments which are passed by various high courts and Supreme Court, setting down the principle of section 34. So section 34 has given only limited grounds to challenge the award. So those grounds include: the award was against the fundamental policy of law in India. The award was the basic principles of natural justice were not followed. The parties were not given opportunity to adduce their evidences. So on all these basic grounds, the award can be challenged. So there are very limited grounds. Now, section 34 is there. Suppose there is an order under section 34 by the court. So that order is also challengeable under section 37. But again, it narrows down. 34 is limited, 37 is much more limited than 34. So we need to understand the implication of it. That is very important. Then the changing times, there are amendments under the Arbitration Act. That is amendment of 15, amendment of 19, amendment of 21. The way new trends are coming up. Recently, there was a discussion with respect to emergency arbitration. So just as I told you, emergency means in case of you need immediate relief. So rather than going through the whole legal process for appointment, which takes 6 to 8 months time, there might be a provision. Still, as on today, we do not have a provision under Arbitration Act which talks about emergency arbitration. This is still in the discussions. Okay. The recent amendment which was proposed in that, this discussion was also there, whether we should have emergency arbitration. One more important thing, we always need to stay connected. So now the way we have tribunals, let's say for example NCLT, then NCLAT. NCLT is appellate tribunal. Okay, and then the Supreme Court is a hierarchy. Secondly, in RERA also we have a hierarchy. RERA forum and then the appellate tribunal and directly the Supreme Court. In consumers also we have consumer forum, we have the hierarchy. District level, state level and national level. Similarly, there is no such hierarchy under Arbitration Act because if you want to challenge the arbitral award, court is the remedy. So many a times this has been discussed as to what are the powers of court and what are the powers of the arbitrator. Okay. Now, very important thing is when a arbitration proceeding is going on, so there a neutral person is appointed who will adjudicate the dispute. He will be called as the arbitrator. So there has been discussion that when we have a ADR mechanism, then why court should interfere? Okay, so there are various debates on this that why arbitral awards are challengeable before the court of law, but courts are the ultimate one who will give the remedy. Okay, so in the last, I think in 2024, there was a proposed amendment under Arbitration Act which talked about having an appellate tribunal. जैसे बाकी laws में we have appellate tribunal, here also there should be appellate tribunal so that we can reduce the burdens of the court. This was in discussion. Maybe down the line, in few years, that might come up as an idea. Okay, that will be brought under the law as well. Next is how does the course has been designed. The very first is introduction to ADR, meaning, types, basic role of the court, how ADR is evolved. So basics of the course. Then the module 2 talks about concept of ADR, the meaning, the definition of arbitration, then difference between domestic arbitration, international arbitration, institutional versus the ad hoc arbitration, purely given under the Arbitration Act. Next is the arbitration agreement. As I told you, again, very important. Your clause should not be vague. A very basic example which I'll give you. It starts with the specific words which you should use. For example, in case of a dispute, the parties may appoint the arbitrator. And second scenario is imagine in case of dispute, both the parties shall appoint the arbitrators. So now here the terms like may, the terms like shall have been used. So now in our normal languages we know that may is gives you possibility, but shall gives you compulsion. So these principles are also followed. We have seen Section 11 application being rejected merely on these grounds that just because may this word was used in your arbitral clause, hence this dispute is not arbitrable. Okay, so it's very important for us to draft the clauses, draft the agreements in such a way that the words which are used in the clause are very much definitive and not vague or ambiguous. So this module will talk about the essentials of it, how to draft it, what are the key terms of it. Section 16, which talks about competency of the arbitrator itself. So here, as when I told you, court will have minimum interference. Okay, so in case if you want to raise any jurisdictional dispute or you want to raise any aspect before the authorities, then arbitral tribunal will have the authority to decide on its own jurisdiction. This is again very important because here we are not wasting the time of the courts. The arbitrator himself will decide the dispute. Okay, whether this dispute is arbitrable or not. This is also an important subject matter. So section 16 for this under this is very important. Next is the module 5 will talk about the appointment of arbitrator. That is what is the procedure, how to appoint it, substitution of arbitration, the role of the court or interference of the court when it comes to such proceedings. Next module talks about arbitral proceedings, that is commencement, filing of statement of claims, evidences, statement of defense, internal applications, orders which are passed. Again, very important timeline. There is a specific timeline given under arbitration law. That is, the very first period is the arbitration proceeding should close within 1 year. Okay. If those are not resolved, then 6 months extension is can be granted by consent of both the parties. So in all, it should be closed in 18 months. But generally does not happens. It takes more than that. So in case 18 months khatam ho jate hain, then parties have to approach the high courts under section 29A to go and ask for additional time. Okay, so again, this is very important. Powers of the tribunal. So tribunal will have specific powers when it comes to giving orders, passing their orders, reasonings, everything. Practical drafting. So this module will help us to understand how to draft the clauses, how to draft the applications, how to draft the statement of claim, what are the important ingredients, how to lead the cases, and drafting is again very important because many times when we see today, because of AI, things have become very easy. But we as an advocate have to be very much diligent because let us take an example. Today, I'm drafting something. I'm filing it in a days, in a week's time. I'm not sure as to whenever the arguments will come on that. So I have to be very much particular, very much thorough when I'm using any word in my draft. Okay. Secondly, denials. Again, very important. So legal drafting is not easy. It is only after practicing, after reading things, we understand. So this is again a practical side of it. The next module talks about the enforcement, awards, and the trends basically. So now enforcement of award. So if we read section 34 or section 33 for that matter, section 33 talks about correction in the award. Section 34 talks about challenging the award. So in all, basically, arbitral award will be considered like a decree only. Okay, now what happens when the arbitral award says that XYZ party should be paid 20 crore rupees along with interest? Okay, now the opposite party is not ready to pay. They are in the process of challenging the award. So now in such cases, what will happen? How to enforce it? Can we take the award copy and stand in the front of their door and ask that give me my amount? This is not how it works. We need to go by the legal process only. And the legal process is execution. Okay, execution is basically filing a separate application before the court of law, seeking that this award was in my favor. And hence, the opposite party has failed to give me my money back. So court should interfere and help me to get my money. So in that case, court will assess it and then court might direct attachment of property also, then when I can recover my amount. Okay. So this is again very important how to enforce the award and challenging the award. Then the recent amendment that we have discussed already, how implications will be there. Now, yes, this is again very important. Who should attend and career options. There are a few questions in the chat box that I'll take up once I complete this module. Okay. Yes. So now target audience is again that we have discussed. Arbitration. See, one important thing what I have always observed is for in our field, okay, we practicing advocates or lawyers for that matter, we need to have knowledge of various things. So I have always kept in my mind, and I always tell all of my students that is a lawyer must know something about everything and everything about something. Okay, this is again very important because our field is in such a way that we need to have knowledge of something. Okay, all the time. Now it is practice. Why we call this field as practice of law. Why we call this as practice? Because nobody is that much diligent, that much sufficient enough to know everything. Every day we are learning some or the other new thing. Every now and then we understand few principles, few legal requirements. Okay. In fact, judges also, many a times we have observed that judges are not aware about the laws as well. Laws means not particularly the general ones, the specific laws. Obviously, it's very understandable that there are thousands of laws, state legislation, central legislation, notifications, gazettes. So we cannot practically imagine that every judge for that matter will know all the laws and all the provisions. We as advocate are also not supposed to have that understanding. It is only when there are legal rights affected and remedies provided by law that is very important. So we should know something about it, and hence it is important for us during your career when it is going on, or once you start your career, then things become difficult for us to learn. So whatever is there is during the course, whatever we are going through. So to learn whatever as much as you can will help a lot. Okay, so this is particularly for law students, fresh graduates, the corporate legal professionals, the ADR researchers, judicial aspirants. Again, very important. Now, career pathways. What we have observed is recently this trend has grown, the need and requirement of ADR mechanism. Okay. So definitely there are good career opportunities because this field will go on. Right now, there are a lot of awareness among various businesses that ADR mechanism is the best mechanism for us to resolve the dispute rather than going through the traditional forum. Okay. So need is, will be very much important, and again to help or assist in handling the corporate matters. So whether you are going for a law firm job or starting your independent practice, this will help a lot. or maybe you are going for your normal in-house role. There also this is very important. And down the line, whenever new laws will come up, definitely this will be one of the important mechanism which is going to help us. Now, the last part for our discussion is how this is going to help us to build careers, and the basic important thing is about the course, how it is going to practically help us to understand. As I told you, reading it through a bare act maybe will not help us to understand that, or maybe reading some article, few judgments about it will give us a slight knowledge of it, but understanding it in whole or in a mechanism, that is very important. So this will again give you practical industrial oriented sessions, live interactive learnings through various practical sessions, question answer sessions, the challenges, the recent case laws, and then definitely this is going to help your CVs as well. Maybe you want to focus into arbitration, so you should do arbitration courses, you should go for arbitration moot competitions, write papers on arbitration, do arbitration internships. So at the end of your careers, or at the end of your courses, you will understand things in detail, and at least you will know your pathways. Yeah, I think that's all from my end. Now we can just begin with the question answer session.
Sir, good evening. Hello, sir. I'm audible.
Yes, yes, you're audible.
Sir, why arbitration is considered so, sir, underrated or undervalued in, sir, proper in the court system or legal system, sir? Because sometimes courts have to impose arbitration on the parties. Please go to the arbitration, or if you have to choose arbitration, you will find the correct justice, or your sir way of justice in the arbitration you can find. But the parties sometimes did not agree, and most of the times parties only, sir, like opt for the judicial decision by the court, not by the arbitration. Why it is so, sir?
See, it is not that the bindingness is not there for the arbitration. Okay. Arbitration is definitely a mechanism where you will get justice. That is for sure, because arbitrators are the one who are going to decide it on merits. It is not going to have in a biased way. Okay. It is only the understanding of the parties. So now what we have observed is only opting for arbitration. The basic reason for it is to save the time, to have the confidentiality. And in arbitration, the proceedings are conducted on the basis of availability of every party. So, in rather than in courts, whenever the court dates are there, you need to stay present in the court of law. Okay, it will run through a normal traditional mechanism. But in arbitration, there are various benefit of it. There, to some extent, you will save time, you might save resources, the decision will be easily and quickly available. So definitely there will be justice. It's not about that only court system will give you justice. But court may give you justice, but it will take a lot of time. It will take its own sweet time. Yes, which institutions provide LLM on ADR? I think there are a few colleges in Delhi, okay, that I had recently heard about. So those provide LLMs as a specialization under ADR. So that is again a very important specialization which they are giving. So that information will be easily available online. What one of the institution which I know is from Delhi, Delhi-based institution. The next question is, if an arbitral proceeding becomes an expensive and lengthy as a court litigation, what is the practical advantage of choosing arbitration? See, to be honest and to be very upfront, arbitration will only help to resolve your dispute in a quick time. Okay. Talking about cost, this has become an important trend that people are thinking that arbitration is expensive rather than normal civil court, because the cost of arbitration is very high to pay fees of the arbitrator, to pay fees to the advocates, basically, to go for miscellaneous cost. Secondly, to go for cost with respect to venue, whatever venues are decided, that cost has to be borne. Okay. So actual cost is very high when it comes to arbitration. When it comes to normal civil court, the only important cost is payment of the legal fees to the advocates, and secondly, pay the court fees. And that court fees is, the upper cap for court fees is 3 lakh rupees. So whenever your claim reaches that amount, or whatever is your recovery amount, 3 lakh is the maximum cap, whether it is 25 crore, 30 crore, whatever is the amount, that is the highest cap. But when it comes to arbitrations, the fees of arbitrator are depending upon the schedules. That is again very important. Secondly, uh, various institutions are there who have their own fee structure. That is also very important for us to understand. So they will charge fees as per they are. Suppose we are referring a matter to a particular institution, so we'll have to pay the charges of that institution also. So it depends upon. So hence, the cost under arbitration is very much higher.
Sir, is it so? So how it is, sir? Why it is written in the books? It is very cost effective. Then the litigation or the judicial system, in judicial system, it is very cost effective. It like sir, वो बोलते हैं कि सर कॉस्ट बचाते हैं, आप प्लीज उसमें चले जाइए आर्बिट्रेशन में. ये सर ऐसा भ्रम क्यों फैलाया जाता है? ये क्यों है सर ऐसा? मतलब समझ में नहीं आया कि सर हमें ये पढ़ाया क्यों जाता है कि आर्बिट्रेशन में इतनी कम कॉस्ट में आपको सर वो डिसीजन मिल जाएगा, आपको रेमेडी मिल जाएगी जुडिशियल डिसीजन की. तो सर ये क्यों सर कॉमन मैन के लिए कि सर अगर क्रिमिनल केसेस में तो होती ही नहीं है आर्बिट्रेशन सर, उसमें तो होती नहीं सर, सिविल मैटर्स में भी सर कॉमन मैन 10 साल 20 साल में सर अगर आर्बिट्रेशन बॉडी लेना तो सर उसमें वो गया ही क्यों सब कोर्ट. एक ये भी तो सर उसमें उठता है सवाल.
See, this is again a practical difficulty. When we say, by any chance, have you studied constitutional law? Constitution पढ़ा है आपने?
यस सर.
Constitution में you have seen such beautiful principles are defined: justice, equality, okay, freedom. So can you practically imagine with the practical life जो हो रहा है वो, okay, the process for BIL, the right for writ petitions, protecting the rights of the public. So is it that easy or practically possible हो रहा है क्या वो? So you know, as rightly pointed out that in many theoretical concept it is stated that arbitration is cost effective, but practically it is not. Many of them do not opt for arbitration just because of the single reason. Now, why it becomes cost effective is that only businesses can afford it. Okay, the huge businesses which are there, they can afford it. वहाँ पे both the amount has to be divided between both the parties. This is only the benefit. But for example, if I am not aggrieved and someone has filed a case against my client has to defend it. So now I have done nothing. Still, I will have to bear the arbitrator's fee. Okay. Now, when it comes to normal civil court में आप जाओगे तो डिफेंडेंट को कुछ पे नहीं करना पड़ता है. If he is not filing his counter claim नहीं है, then there is no fees. Only advocate की fee pay करो आप, but no fees to be paid to the authority. But in arbitration, you will have to bear that cost. Okay, no doubt that at the end of the proceedings, you can claim that cost. That is a different thing altogether. So, practically speaking, arbitrations are expensive than courts. But however, there are various regulations. जैसे for example, Bombay High Court ने एक upper cap लाई है. That is regardless of the amount under claim, counter claim, 30 lakh is the maximum cap जो एक arbitrator को fees pay की जाएगी. Otherwise, it's definitely a maximum, a massive amount which is involved.
थैंक यू सर, थैंक यू वेरी मच.
Yes. Anything else? Any other questions? I don't think there are any more questions. Can we wind up, Sakshi?
Thank you very much, sir. To conclude today's session, we extend our heartful gratitude to Perspective with us. Your insightful guidance has truly motivation and mediation with added clarity and enthusiasm. We platform provided in the chat box as your suggestions assist us in refining future sessions. We would now love to take a virtual group picture. Kindly turn on your video cameras for a quick snapshot. Please everyone turn on your cameras for a okay, wonderful. Thank you all for joining us today. We look forward to welcoming you to our upcoming webinars. Have a wonderful evening and remain engaged with the Collective Council. Thank you very much.